then and said, "You've done something totally different to what I've got planned. I need to very quickly rejig what I cover over the next, what have we got, 6 hours or so, today and tomorrow." So today's a bit of an odd session, an hour and a half, but we can make a start. And we'll just stop at 7, and I'm not going to worry if we're in a neat place or not, because we'll pick up tomorrow morning with revision. It's always a bit difficult to know how to plan it from a timing point of view, because it's a bit of an unknown as to where the students will be at. My intention then is just to have a quick chat back through the syllabus, which should all be, as you just said, fairly fresh, given that we were only talking about it 3 weeks ago or 2 weeks ago, whatever. Just kind of giving you an overview as to where I'm at insofar as question types and method of assessment is concerned, given the uncertainties that we had about that previously. That won't take too long. Then I've got the 2017 paper here, and a copy for each of you, because, as I said a moment ago, it's easier for you to have this in front of you than on the screen, because some of the questions are well over going on for a page. And we'll start working through that. But I've also then tacked in 2 Jersey papers. The reason being that there are questions in here which I have written previously. So obviously the Guernsey past papers were written by Fran and previous adjuncts or whoever. And I thought it might be beneficial to, by contrast, look at some of the questions that I've written on the JLC, so you can get more of a feel for my style putting questions together. Now, the fact that they're on the JLC makes no difference whatsoever, because they are simply fact scenarios. And so you could apply these to the law of any jurisdiction, I suppose. There are questions in here that do go to specific issues of Jersey law, but we'll ignore those because we're just concerned with the fact patterns on problem questions. So that's my intention, and then to work through a few of the previous questions in the 2017 Guernsey paper, and try and get ourselves into Fran's head in terms of marking and how she's split these mark schemes up. And then, as I said, get into my head insofar as the JLC questions are concerned, and how best to approach your answer to these questions and where the marks are, and I guess come to some kind of common formula for answering them. The topics then we have gone through over the last 2 study weekends pretty briefly, haven't we? We've looked at company law, we haven't looked at trusts, we've looked at security, we've looked at foundations and partnerships briefly, and we've looked at the regulatory laws. We haven't touched on any aspects of commercial law, and in fact, Fran and I both laughed when we remembered that competition and competition law is part of this syllabus, and we've completely forgotten. But I think the headline point, which came up in the last study weekend, is the fact that we haven't taught something face-to-face doesn't mean that it's not going to be assessed. You should go into this assessment, of course, being prepared to answer a question on any topic within the syllabus. However, as we'll come on to in a few moments, there are certain hot topics that lend themselves better to assessment than others. And it just isn't realistic, I don't think, to expect you to go in having a complete knowledge of every single part of the study guide, particularly when, as we've discussed ad nauseum, the focus now is to try and turn this into a more academic type assessment, and certain of the topics simply don't lend themselves to that because they are purely procedural or transactional. Company law we'll look at separately. Trusts is so incredibly brief. insofar as its coverage in the study guide is concerned. Frankly, those elements should be extracted and placed elsewhere. Aha, here he is. Come on in. Don't be silly. You've missed the point where I tell you exactly what's in the exam. So sorry. Not really. Of course I wouldn't. Of course I wouldn't do that. Let's just mark you in. No, we're just chatting very briefly through the syllabus, just to refresh our memories, because we've all have other things to do. Why is this not? Banking and security. Well, we haven't really looked at banking, and there's no significant coverage of banking per se in the study guide. Rather, it's really reserved to security and the taking of security. And then the regulatory issues that come from banking and licensing, obviously. Foundations grouped in with partnerships and the various types of incorporated partnership. Although they're banded together, I think you've got to treat foundations and partnerships entirely distinctly, entirely separately. Although there is one example in a past paper where the ideas are that the concepts are brought into one problem question, but we'll look at the detail, but the nature of the question doesn't keep them entirely distinct. So I would, again, take the same approach. We didn't look at any detail at LLPs because we've run out of time, but frankly, reading through law as far as it relates to LLPs, there's nothing particularly tricky. There's nothing that particularly stands them apart from the way in which a company operates ultimately and the way it's treated in law. Insofar then as the regulatory laws are concerned, it's difficult, as we saw in the very first study session, to neatly condense what are procedural regulatory requirements for licensing and the powers of the Commission in certain situations and certain events where somebody fails to obtain a license or breaches the terms of their license. Charisma's point was there is a significant overlap between the various laws that go to licensing, but nevertheless, you've still got to bear in mind that there are differences. And although you can take a common starting point, it would probably be easy to go on to make a mistake as between the application of banking law as against the, I don't know, the fiduciaries law, for example. And I don't have any particular recommendations for how you approach the revision of licensing, save that. Remember, you'll have the relevant law in the exam. If you're being assessed on fiduciaries, you'll have the fiduciaries law. If you're being assessed on banking, you'll have the banking law. And so you ought, I think, be able to distill it to some kind of fairly broad overview for the purposes of revision, with the safety net of then going into the detail in the exam. As far as commercial law is concerned, as I said, we haven't taught it face-to-face, but the study guide does include the competition law. As far as the company law is concerned, you can, I think, realistically expect that the balance in the assessment is going to mirror the balance in the syllabus, which is that circa 50% of the syllabus, if not slightly more, comes from these topics, pure company law. There are a huge number of topics beyond those which were taught face-to-face. We simply went through in the taught sessions those topics which Fran felt would be the most beneficial for a common starting point as between experienced practitioners and somebody who is coming into the company law afresh, as against those topics which we flagged for self-study, which are more or less entirely procedural. if you're not looking to the practical use of, I don't know, a PCC as against a non-cellular company or something in practice, which is what this syllabus is now supposed to be trying to avoid. Beyond those kind of practical considerations, these topics are just purely procedure as far as the actual law itself is concerned. And I identified in the last study weekend, didn't I, that some of these you might see as being fairly useful bolt-ons to those topics which we taught face-to-face. These lend themselves to problem questions because they're areas of more esoteric type law where you can get into the uncertainties of what the law itself says, how the courts have interpreted that law, etc. Those lend themselves to problem type questions and giving a practical advice as you would in a more litigious context in practice than these topics in general. However, issues going to insolvency, disqualification, fraudulent and wrongful trading, I said, can be useful bolt-ons to a wider problem question. They can be useful catalysts for something to have occurred in a scenario, such as to lead to the fallout between the parties involved. It's those 5 topics there, striking off administration, insolvency, winding up, disqualification, fraudulent, wrongful trading. But of all of these, have the most interesting issues, I think. The remaining topics are really just administrative type procedural matters, and it's very difficult to draw out problem type questions from them. Read into that what you will. I went through and just set out here how over the years, whether I've been teaching on a bachelor's type degree or on professional courses, how these company law topics can be split up between different question types. And again, that falls in with what I've just said about those taught topics as neatly coming within those which lend themselves to problem questions as opposed to just knowledge-based procedural type questions. Now, what I think I can say then is, and as I've indicated previously, there's no appetite, certainly in this module, to simply test your knowledge. There's no appetite to simply ask you procedurally. I'll take an example from this Jersey paper. What is a scheme of arrangement? Or this poor example, because it's talking about schemes of arrangement, but what is the first phase of the procedure for obtaining approval of a scheme of arrangement, which in the Jersey company's law is just set out? And the answer to that for 5 marks would be to regurgitate what the law says. There is no appetite for that here. We want to assess you obviously in a more practical sense, and again, I think it's reasonable for me to say that across all of the questions on this paper, you will be asked to give an advice. Now, there may be elements of procedure within that. What is your advice, and how can that outcome be achieved? You may necessarily have to refer to particular procedure, but within the context of what you're advising that client, as opposed to what you have here, which is simply regurgitating what the law says in order to achieve your 5 marks. There are 2 slides here then that follow through the various topics and split them up between the various categories of questions I saw. Those questions dealing with a critical discussion, there's an example here from the 2017 Guernsey paper. In the context of a rich family, a high net worth international family, who want to create a structure to hold their wealth, you're asked to advise. You're asked to compare rather than advise. You're asked to compare and contrast the key features of companies, foundations, and trusts. That, for 15 marks, is what I mean by critical discussion. You're looking at 3 different options without really applying them to any particular defined need. You aren't given any information here that really lends you to be in a position to say a company is better for this client because, or a foundation is better because, or a trust is better because. You don't have that level of background factual information to give that advice. You're simply being asked to compare and contrast the key features of company, foundation, and trust. That is a pure critical discussion. Effectively, you're looking at key features, pros and cons of them. There's no real advice there. So again, that's something that I'm trying to shift away from. This is Guernsey. That's this. I'll hand these out in a moment. So that's 2017 Guernsey. So again, I'm trying to take it a bit further, make it a little bit more practical. Just trying to think whether or not there's any element of that in the paper which I wrote, but I don't think there was. I'll send it on. What I've got here is 2017 Guernsey paper, which we'll look through. But on the back of that, 2 papers that I wrote off the JLC, the majority of the questions within those papers we'll ignore because they're the types which I've just been discussing. They're just knowledge-based tests. But the reason why I've included those is because we can look at some of the problem questions tomorrow, which will help you become a little more familiar perhaps with my style of putting a question together and where how I've built up the mark scheme for that question, given that you're generally just being asked to advise 25 marks, which may or may not be useful for the purposes of you now sitting down and writing a paper that I've written, as opposed to all of the Guernsey past papers, which were either written by Fran or whoever the predecessor was. So hopefully that will be of some use. And for what it's worth, maybe we'll have a more general application if on the other modules we're being assessed on pure problem type questions. Or you're, again, just being asked to advise apply 25 marks. I can't, and obviously I won't tell you what's in the exam directly, but you can read between the lines, no doubt, of what I've been saying. So our focus, problem type questions. We've got certain topics that lend themselves to those types of questions. Other topics, as I said, these kind of bottom 5 here, they lend themselves to being built in as a kind of flashpoint, a catalyst for something happening, fallout between parties or whatever, or just bolt-on considerations to a set of facts insofar as the company's law is concerned. As far as banking and security is concerned, there's very little to draw out of the security interests law. You've got certain types of security and you've got different ways of taking security over those different types. But even then, those different ways of taking security are really not that different. It's just, I think, aiming to be precise in the advice that you may be asked to give as how to take security in a certain situation. And we'll look at an example of that first, but bearing in mind that if you can't fit within the specific requirements that go to, for example, taking security over a life assurance policy, you've got the fallback option of the broad category under section 6 that deals with other types of intangible property. So we'll look at that in a moment. My point being that insofar as security interest is concerned, is a really narrow area of law. in terms of what you could ever be asked to be assessed on, because there are simply certain types of security and different ways of taking security in those circumstances. But don't forget, beyond the security interest law, you've got guarantees, you've got liens, you've got pledges. Now, Chris talked about them very briefly, went into some detail, I suppose. But bear in mind that those are also within the syllabus, but that there isn't a huge amount to say about them. And so if you're being asked, and again, we'll look at an example in a moment, but if you're being asked to advise on the giving of a guarantee, don't feel that you're expected to write a page or a page and a half if the mark scheme, if the available marks are broken down, then be guided by those 2 marks, 3 marks, or 5 marks. You know, it's a very short answer. It's only a limited amount of information that you're being asked to give. But we'll look at an example of that first in a moment. Insofar as the regulatory laws are concerned, again, it's just going through different types of licensing. You know what those laws are. And you know, realistically, you can expect to be assessed on at least one of them. You'll have the benefit of that law in the exam, and you know it's going to be pretty procedural because that's the nature of those laws. How do you obtain a license? What happens if you breach a condition of that license? What happens if you, or what could happen if you carry on in business without the relevant license? Those are really the only issues that come from licensing. I think that's the only real shortcoming of my having chosen this particular paper, is that it doesn't really deal with licensing, but it does deal with the other topics. Insofar as foundations and partnerships are concerned, again, you know that our aim really is to move away from, as I said a few moments ago, here are 3 different types of structure. What are their pros and cons? What's good about them? What's bad about them? And we're not really looking to ask you about their particular suitability in certain circumstances. I suppose we could. It's still going to issues of, well, I don't know, you've got a foundation. What's the role of the guardian? What duties does the guardian? What happens in certain circumstances? And similarly with partnerships, you've got a partnership, or you've got an LP, or you've got an LLP. What happens in certain circumstances where, I don't know, someone abstracts property from the partnership, or what happens if one partner causes the partnership or an LLP to enter into a transaction and the partnership suffers loss? Who's liable? Who's responsible? They're pretty straightforward issues, but again, all fairly litigious, you would say, in their nature. Looking at this paper then, we know the headline points: 4 questions, 3 hours, 25 marks per question for a total of 100. You're provided with various laws that you will need, and no more. Now, flicking through, you can broadly see, I think, question 1 is dealing with, I'll let you read the facts in a moment, but question 1 dealing with securities. Question 2 dealing with companies, foundations, trusts, and partnerships, which sounds a lot, but it's in a fairly general sense. Question 3 dealing purely with, no, not purely, I suppose, it's a trust and fund administration company, so there might be licensing issues in there, but fundamentally dealing with the corporate law, the company's law, and similarly 4 dealing, I think, more or less entirely with the company's law. So that balance there between the questions, tying in with what I said earlier, which is roughly 50% of the syllabus is the company's law. The remaining 50% made up of the various other topics, and you can expect that, I think, to follow through in your assessment. The first question, question 1, impressed me because it's 25 marks, dealing, I think, almost exclusively with the taking of security, which I thought is no mean feat. How do you see it? Split up into 3 sub-questions. Okay. The first question for 15 marks was asking you to advise a big bank on how to take security and document it and obtain guarantees from shareholders. It's 15 marks, so a nice weighty chunk. And when you then look up a line, you see you're being asked to advise across 5 different forms of security. So do the maths, you could roughly say you'll be getting 3 marks for an accurate answer as to how to take security in each of those different scenarios. Now, I would say that that's probably, yeah, more or less right as a rule of thumb. Save that, you will have a bit of an imbalance as to the extent of discussion on those. You might have a little bit more to say about taking security of a bank account perhaps than over a company subsidiary or an insurance policy. However, it's important to make sure you break down what you're being asked to advise on precisely. It's not only how to take security, but how to document it. And so that necessitates looking to Section 2 of the Security Interests Law and talking about the formalities, I think, of security agreements. Now, those requirements are common to any form of security agreement, irrespective of the nature of the security itself. And so when I say you've got 15 marks split between those 5, well, actually, you've also got to discuss security agreement. And there'll be some marks attributed to that. So suddenly you're going from 3 marks for each of those to possibly slightly less, and something more like 2 and a bit for each one. And the amount of effort that's going to go into describing each one is, well, from my view, I think probably worth more than 2 marks, but there we go. So advise big bank on how to take security, okay, and document it. So you've got to discuss the formalities for security agreements and how to obtain the guarantees above. Well, that's really just rehashing E from that list. If then you're being guided by the mark scheme, you're thinking, I've got a couple of marks for discussing each of these. I don't need to be going into huge amounts of practical detail. I need to be covering off the headline points from the law. So taking security over a bank account, for example. There are straightforward provisions set out in Section 1, Subsection 5 of the Security Interests Law that deal with the scenario where the security is being given to the bank which holds the relevant account. That would be the first kind of building block for dealing with A. And it is pretty much a rehash of what Section 1, Subsection 5 says. I'm not sure if there's much more you can add beyond that. You would, though, be losing marks if you fail to deal with the second element of A, which is it's unclear at this stage whether the company holds this with big bank. The point being that Section 1, Subsection 5, as I said, deals only with the scenario where the bank being granted security is the bank which holds the account. If the account is held with some third party, then you're taking security under section 1 subsection 6, which is the general blanket provision for security over any intangible, movable property other than a lease.
On the first step, wouldn't we need to establish a joint bank? Because I don't think we've been told where Big Bank is situated. I mean, would there be any marks for saying that, or should we just assume that?
Having not written the paper, and having read it, I don't think that would be the intention, frankly. I think that's more likely to have been an omission in the fact pattern. But I come back again to my reading of what you've got here for 15 marks. That as a discrete point is not something that's going to lead you on a tangent to writing paragraphs and paragraphs and paragraphs. And so if that was something you flagged as a point on which you needed further information, then I would say, yeah, within 15 marks, that is the extent of how you would deal with the point. And you would then proceed with your advice under section 1 subsection 5 and 1 subsection 6 on the basis that, yeah, you need further information, but on the assumption the Big Bank is based in Guernsey, this is the position. I can't obviously speak for all of the modules, but certainly that's how I generally say to students, if you've got an uncertainty, you've got an inconsistency, that's how to deal with it. Because it's neat, it's quick, it's only a couple of sentences worth of writing, whereas I know this isn't a good example, but on some certain issues, you could end up going on a tangent, paragraphs and paragraphs, and you've got to try and avoid it. Yeah. The other point that I suppose is that stems on here is you're necessarily, I think, having to discuss section 1 subsection 6, the general provision for security over any intangible movable property other than a lease. However, you're likely to come back to it again, certainly for D, where you're discussing insurance policies, because there's a couple of points that arise there. It's not specified that it's policy of life assurance, which is what section 1 subsection 4 deals with, and it's not specified whether or not a policy document has been issued. Security is only taken under section 1 subsection 4 if it's a policy of life assurance and a policy is a documented policy has been issued. If those conditions aren't, if either of those conditions aren't satisfied, then again you're falling back under the general provision of section 1 subsection 6 for any intangible movable property other than a lease. My point being that I don't think it's necessary for you here to discuss the detail of section 1 subsection 6 twice. I don't think there's any need for you to duplicate it as between your discussion under A and D. I think it would be sufficient under D to simply refer back to your earlier discussion dealing with section 1 subsection 6 and simply state that if the relevant policy is not a policy of life assurance and or if policy hasn't actually been issued, then security could still be taken pursuant to section 1 subsection 6 as described above. So I don't think there's any need to duplicate whenever that issue arises, and it possibly will as well with some of the companies. In terms of advising Big Bang on how to take security for either A or D, I'm not sure how much more you can really add beyond what those core provisions provide. And to particularly within the context of the number of marks that are available, because that's just dealing with two. You've still got to deal with B, company subsidiary, C, stock in trade, and E, personal guarantees. Well, I'm presuming, and I'm open to whatever whatever your views may be, that for B, the intention is that that would be taking security over securities, i.e. over shares under section 1, subsection 3. I presume that that's what the intention is. Providing, well, it says it's a Guernsey subsidiary. I presume that's the intention there. I began to second guess myself because I was thinking, if I was writing this, I wouldn't have just chucked them all in because securities and life assurance are just simple, straightforward, and more or less identical in their provisions. Bank accounts add a little bit more, so there's a little bit more discussion to be had. However, I think that was the intention. It's simply taking security over securities under section 1, subsection 3. Again, that assumes that you've got the relevant certificates in hand. C, stock in trade. Again, entirely open to your views, but I'm presuming that you would take security of the stock in trade by way of a lien or a pledge, but I can't see that being particularly practical, certainly not insofar as a pledge is concerned, because you have to have physical possession of the property. A lien is I suppose it's a restriction, a form of restriction that doesn't necessarily mean you have to have physical possession. In the UK, this would be covered by a floating charge. Any particular thoughts?
I see it done by way of a preference share over
Okay.
just the company, which sometimes it would in the event of default, particular assets of the company. Rather than cash.
I thought that was a bit, when I was looking through the options thing, that's a bit archaic.
I don't think pledges.
No.
No.
Yeah. I've got an answer there, haven't I? Don't really just pledges and Guernsey. Don't really have full insurance.
I've never heard of that.
Yeah, I think Chris talked about this basically. I remember. I know we don't have full insurance for that. I can't remember if there was something. But I think in your solution, you might get a point for it, but it's probably quite tacky. Right? So
that's what I wasn't sure about. You see, I couldn't see what an obvious answer would be.
Yeah. Maybe they're just saying, tell us why you can't do it.
Yeah, maybe it's a negative rather than a positive. But certainly there's options there to be discussed.
You can't take security over like inventory that's
No. Yeah. You take the.
What about the cash?
Sorry, scans.
Yeah, I think you don't want to get over exercise on that, right?
not on Friday.
No.
So again, that's a bit of I thought that was a bit of an odd one. But as Laurent said, it's probably, it's looking at it in negative more than anything, which is it's not a straightforward answer. E then, personal guarantees from the shareholders. Again, no specific neat provision to look to, as in the case of bank accounts, subsidiary insurance policies. But you can talk about guarantees, you can talk about what a contractual guarantee is. You could talk about the rights for what it's worth. I wasn't sure if there was anything specific in the Guernsey law that meant that the reference to the shareholders was relevant. I don't think it is. But again, I'm open to your views. It's typically directors who give PGs, but there's no reason why a shareholder couldn't. It is then, I think, a fairly...
Can I ask you like an exam technical question? Obviously, we see five sub topics for 50 marks, 2 marks each. But are there? Can you pick up 4 for 1, 2 for 100?
Yeah, potentially. Yeah, I just say that as a guide for your purposes, sitting down and thinking, how much have I got to write here? Because there's 15 marks about taking security. And if I'm talking about taking security over a bank account, I've only got 2 points I really need to make. And likewise for the company subsidiary in Guernsey, the insurance policy, there's not a huge amount to say because the procedural requirements for taking security are really quite straightforward. Say that I said you also need to remember that you're being asked how you document it, so you've got to discuss the security, which will skew what I said earlier about just taking that and dividing it by 5, because there'll be marks there for discussing the security agreement. The discussion of the guarantees, there isn't much law to feed into it. A guarantee is a guarantee. It's a contractual obligation, like any other. You can talk about the DWATs, but again, even that is going to be 2 sentences each, maybe, just to say what they are and what their effect is, what their effect is. And I think Chris said to say that they're not used particularly often. I don't know, whatever your kind of practical view might be.
I'll go if anybody else has. Well,
I guess the point to make here is get your personal guarantees from like shareholders. Yeah. So you'd say get your guarantees in your guarantee document. 1 point maybe.
It's a contractual. It's a contractual guarantee. That would be, from my point of view, there'd be a mark for discussing that it's a contractual rather than any other form.
Like a statutory one.
Mm-hmm.
Okay, yeah.
That doesn't exist as a creature of statute. This is a contractual obligation.
That's something I wouldn't think to spell out.
Because its enforcement is contractual. It's a breach of the contract. That's what it is. It's simply a contractual obligation. It's a bargain between 2 parties.
Yeah. That's an obvious point that needs to be made.
It's not the obvious point in writing.
Yeah.
Yeah.
Again, no, you're right, Rick, because how to document it. We're being asked how to document it. Well, we all know what a guarantee looks like. But this goes without saying that it would be in writing, wouldn't even.
Yeah. But then the only thing I was going to say is you've already mentioned the DWAs.
Sorry.
You would just say, get one figured out, so whatever institution, definitely get a point for that. That's the other thing.
Explain what they are and, yeah.
Maybe explain what there's more than one shell, I guess. So between them and the company, and the easier on it. That's 2 marks.
But I'm not even sure if it's going that far, to be honest, because you're not told on the facts. Maybe they want to, I don't know, specifically delineate their liabilities and
You
the
just flag it on and
guarantees.
say
I don't know.
considered in practice, it would be excluded typically, however, you know, in this scenario.
Again, that's where you just
You
want
get
to
scenario.
you just want to be
Yeah.
careful
Yeah.
that actually you've still got another 10 marks over 2 other sub-questions to go on and discuss. So as long as that would be a very limited discussion of what you would do in practice. You?
Unless it's like a part of marketing activities.
Is there anything particularly surprising? I know there's some uncertainties, but is there anything particularly surprising in what you're going to get marks for there, or what you're expected to discuss? Before we move on, sticking with the 15-mark question. Probably you'd write a page. You'd write about a page, I would have thought, getting through those. Yeah. Well, yeah, then, as Jasmine said, for 2 marks, you go on to taking security over shares in the subsidiary if it was an Alderney company, which, although in the study guide, there are some areas where we touch upon the law of Alderney. Frankly, I'm not going to assess you on. But, you know, for a quick 2-mark question, you can see why they tracked it in, because it's a
It's a different company as well. Don't they have a security register for shares? It's not worth the 2 marks.
Most good is normal.
Oh, is that right? That's
Well,
good.
I think
I suppose it doesn't. Yeah.
I think again, it's asking for a negative for us to advise on all people. Unless is it something to discuss with this sort of
now I was in that as a different answer.
I think we should just, since we're curious, let's just look at
Well, while you do,
You can move on if you want. Yeah.
while you do, that's unbelievable, isn't it? It's actually 25.
This is how you cack up your exam.
Oh, right.
Let me tell you something about all of these.
What I like is that you said, you know what, 2 marks, just move on. That's decisive. I like that. The majority, I tell you, in my experience, the majority of students would sit there and think, come on, right, what is it? What is it in Aussie? Like I said, it might be a negative. It may be no different. But people would sit there and stress over 2 marks.
Mark down for wrong answer.
Yeah.
So you just put something down.
No, your marks build up.
So if you
0 up.
good guess,
Well,
based on
I mean, it's an interesting point, because where you've got problem questions, and like I said, I'm not going to really assess you in this way, but it's worth just recapping the law and looking through how these questions are phrased. It's a good point, because, as I said, when we're looking at problem questions, you've necessarily got to have a bank of marks, which is set aside for the advice that you give. It's not an objective assessment, it's just 10 marks, say, which is entirely subjective. How good is the advice that the student is given? How thorough is it? How accurate is it? But accurate rather than correct, necessarily, because you can have 2 sides of a coin. And generally I say the best answer will not come to a conclusion, because typically I mean, it's probably more so back home, but typically we say, do you know what, it's in the judge's discretion. We're going to put this before a judge and the judge is going to decide, rather than it being a black and white answer, you're right or you're wrong. If there's conflicting arguments and you set those arguments out, there's no reason why you shouldn't get your bank of marks for analysis. The fact that you didn't come to a conclusive, definitive answer, it doesn't mean that you're wrong or that you should be marked down at all.
I'm not originally an ethics, so I just hear it, so the client comes to his own.
Well, I just always have my professional indemnity insurance in the back of my mind, and I just think, well, look, if I give you two options and I don't commit to either, then I can't be wrong, can I? I think my oft used phrase as well is your money. Do you want to gamble it or not? Maybe that's the nature of my practice because I'm always with the bad guys. No, the point of these, for these scenarios, Oliver, look, you're going to be given, and we'll come on to them, but you're going to be given a set of facts, and those facts are not intended to be definitive. They're not going to be the intention is not to bring you to a final conclusion.
But
To lay out what are the options, what are the risks. On what, sorry?
On the first question.
Yeah.
Someone being in the federal refuge. I don't really know that this will make any difference to their state, but turns out that the inquiry company is actually owned by 4 of them, not just 3. And Andre is currently traveling, rarely in contact. But there's something you're supposed to comment on somehow that
This is
you
what I
may
was
not get
saying.
the person guarantee easily because he's away.
For me as an examiner, I would just think that's pointless.
Well, it could be,
But it's, as far as the guarantee itself is concerned, it still doesn't make any legal difference. There's a practical difference, isn't it? Whether or not you can get hold of the final shareholder. Is the big bank content with just taking guarantees from those shareholders who are available?
it could be an ethical question.
That's right.
So,
Anyway,
I don't know if they still do them.
yeah, it said it in the.
So maybe with that would say, I'd be concerned to prepare these without instructions on possible complication.
You're actually
Drafting a guarantee for them to give.
Anyway, look, that's my favorite. I was just,
I don't know, I suppose, but ethical issues.
Well, that's.
So
well, we know.
I'm an ethical anyway. I'm not the right person. So I'm not the right person. Very good. So that's 18 hours, and that's the impression that I've left you with, which is rather unfortunate. Moving on to the final part of this question, which is with 8 marks, which I thought was rather generous because you're now being asked, and again, maybe I'm missing something, but you're being asked, what are the options available to Big Bank if it needs to move quickly in the event that the business defaults on its loan? Now, again, to me, that's all pretty procedural. You can talk about notice of default, you can talk about the procedure for sale. I'm not sure that gives rise to any practical issues. It's just a discussion of the procedural steps. Notice of default where necessary. How to exercise power of sale or application. I wondered if does the 8 marks come from the fact that you're having to reflect back on 5 different forms of security, but even then, those which you've taken security under the securities law are all, they're not really any significant differences. The stock in trade, I suppose, is the difficult one because it depends on how you've advised the bank to take security, if at all, if it is possible. Because one student may have said it's not possible, another one might have said, like me, oh, I don't know, here are some archaic things that you could do. And someone may have given a very technical answer, like Oliver, and security of a preference shares. In which case, you might have 3 different answers potentially on that, and I don't know without the benefit of having a friend who to ask what the correct answer would be.
I guess it would be because of sharing, that sort of stuff.
Yeah,
getting where the focus is.
Getting your house in order.
Yeah.
Yeah. So it doesn't advise you on steps, does it? Provide the initial advice. Sorry, it doesn't ask you to provide
To be in a position
on the
to
options.
move quickly.
The options available to Big Bank. Yeah.
What's that house in order? House in order?
Get your ducks in a row.
I said, get your house in order. I said, get your house in order.
I'll get your house in order, sorry.
Sorry. Speaking too fast again. Yeah. So I thought 8 marks seems a bit
Yeah,
generous.
we have around that.
I mean, if we want to vote anything else on, we might have to talk about whether they actually want to follow enforcement, whether they want to try and get other security first and kind of carry on. What sometimes they might be worth some more marks, depending on what the examiner is thinking.
Yeah. My point that really of looking to this question 1 is because it evidences, I think, how there are only limited ways in which you can assess security interests as a topic. The content is limited. For certain types of security, the law is entirely prescriptive and you simply follow what the law says. It would only be if you are, the only uncomfortable points would come from stock and trade, which I don't know what the answer is anyway, and guarantees. Those would be the only uncomfortable points, I think. Are there any particular issues arising from securities that anyone needs clarity on that I'm not suggesting I can necessarily provide, but which we can put to Chris? Because again, the adjuncts remain accessible, and it's just if anyone did have any particular issues, then or concerns or questions, etc., then it's preferable to put it as a group.
I think they may pop up during the
Revision, fine. Yeah.
And in which case we can bring you to everyone.
Yeah, fine. Because it's my point being it's just useful for everybody, of course,
I think
to have the benefit of the
Chris's
answer.
Stuff is very quick and very knowledgeable. I think when I go myself, I'm sure there'll be 1 or 2 questions.
Yeah. Okay.
I mean, that's
The second question I referred to earlier. So you've got again 25 marks. And it's this first question where for 15 marks you're being asked to compare and contrast the key features of companies, foundations and trusts with a focus on the availability of information, so on transparency. It's incredibly open-ended. What are the key features of companies, foundations and trusts? However, when you start to think about it, there are only certain comparisons that you can draw as between companies, foundations, and trusts. And I'm not going to spend too much time worrying about this one because I'm simply not intending to assess you in this way, but you would be looking to, for example, the nature of the structure. Does it afford any kind of limited liability, perhaps, or protection to its beneficial owners or its beneficiaries? Who are the officers that are involved in each of these type of structure? What are their potential obligations? What are their potential liabilities? Those are the headline points, I think, that you can compare across the three. However, you've got 15 marks, so you've got to limit your discussion and focus on what you're truly being asked about, which here is transparency, the key features of each structure, including what information would be publicly available. So if you split 15 marks across the three to get 5 marks for each structure, and think that within 5 marks for each structure, you've got to talk about the key features and transparency, you can start to see that actually the amount of information you're being asked to give there is more limited than an initial read of that question would perhaps suggest. It's not only comparing, though, it's contrasting. And to me, as an examiner, as an academic writing exams, contrasting is critical. Contrasting is pros and cons. You are, though, only given very limited facts on which to assess the suitability or pros and cons of those structures for the family in question. So it doesn't necessarily remain a fairly academic discussion. Moving on, though, the second part for 8 marks, which again seems rather generous. You're now being asked to advise on a more particular issue. It's fact-specific, investment is going well, but this particular member of the family who's invested in an LP has made a large capital contribution and wants to take on a more active role in the management of the LP. So here you're being asked to give an advice. It's worth 8 marks, which, as I said, seems fairly generous. What's the answer?
Well, the safe was take part in management. We just go through them. Well, I think there's probably 8 of them, actually. Yeah.
But what are you doing? What are you doing? You're just reciting the law, aren't you?
Yeah.
That's where that comes from. Personally,
will we get questions on that? No.
Personally, if I was sitting there, I'd have to kind of overthink whether or not I was even going to write down every single one, or just refer to the relevant section, which is 12 subsection 4 of the LP law. Because for 8 marks, it's about a page, I think, maybe a page and a half in the law itself, that goes through all those carve-outs, the different things which won't breach the overall prohibition on taking part in management. Across those 8 marks, though, the way I saw it is that if you break it down, obviously what Oliver said is right, but you've got to make sure you're ticking off the boxes. So what is the starting point? Starting point is 12 subsection 1, prohibition. A limited partner may not participate in the conduct or management of the LLP's business. And the second part to it may not transact on behalf of or bind the limited partnership. That's the starting point. So that's where you begin with your advice. You take him to section 12, subsection 1, and you tell him what it says. You would go on to explain subsection 2. He has limited rights of inspection. He can inspect certain financial information, and there's a broad provision within that which says he may advise the general partners. There may be a sentence to there may be a sentence or two of discussion on that point as to the possible uncertainty then. What is the tension between being able to advise the general partners on certain information and not being involved in management? There's a potential tension there. However, you then move on to whichever way you do it, section 3 or subsection 3 or subsection 4. Subsection 4 sets out, as Olga said, the various exceptions to this. These are things which will not be deemed to be a breach of the general prohibition. And there's section 12, subsection 6, which says that that list is not exhaustive. And so your advice is probably going to be, well, you've got to be careful. There are carve-outs, but the provisions in section 12 are inherently uncertain. The consequence of being found to have breached the general prohibition under section 12, subsection 1 is, and the consequences are set out in subsection 3, that for whatever period of time he's acting in contravention of the prohibition, he'll be liable for the he'll be liable as a general partner. Now, you're working through then 4 or 5 subsections of section 12. You're necessarily referencing them. You're setting out what they say, but it's pretty much just regurgitating the law. And there's some fairly superficial application to say, well, you can't participate in management except in limited circumstances. You've got to be careful. And if you breach, here are the consequences. And there's 8 marks in that.
Well, I've very recently come across a case where there was a large disposal through a limited partnership where, you know, other limited partners taking management decisions. We brought that up. And from a major law firm in London, said it clearly talks about that. And they said, well, that's fine, you think that. We want your opinion on that. And you know, because it's very easy to figure out.
Yeah, absolutely.
Yeah.
I mean, it's all the wording of section 12. I think just creates so much uncertainty. It's so grey. It's not black and white. It would be a nice one to, I suppose, assess on from that point of view, because again, you can't give a determinative answer one way or the other, unless it's very clearly. But even then, you've got the fallback. This list is not exhaustive. Well,
Is that case now?
Just a corporate transaction.
You better write in the first case.
Yeah, so I think that's it.
I mean, once you build it up, you can kind of see your 8 marks, but you're not really working for it, providing you remember that section 12 exists, I suppose.
Presumably you would be given
You'd have the
the
element,
law,
yeah.
so you.
Even if you didn't know, you'd flick through.
Index, wouldn't you?
But you could answer it without any prior knowledge. The first question would be trickier. But the second question. And then the third question, what might a Guernsey LLP be used for? I can't remember whether or not Caroline covered it off in her kind of overview. I think she might have, because we were talking that she said some of the firms have converted to LLPs.
Yeah, that's what that's.
Apart from.
Sure.
So you could say an LLP would be used to run a law.
Professional services firms.
Is there anything Guernsey centric in financial services?
No.
Is there any reason to? I don't. I can't see why there would be. I'm not sure what the LLP would offer as an advantage over other forms of structure. Or just something within the mysteries of the financial services industry. Yeah, I don't see that it affords any particular benefit.
Law firms, yeah.
Not again. We can have a massive wave of second GPs that have been contracts when.
Okay.
Yeah, I was going
What are
to,
the KPMG things?
No, so basically the partnership in the UK existed and there was a tax decision that came in 2016.
Oh yeah.
Which incorporate a whole load of LLPs to become second speaking general partners.
That's the secretary.
That's the only other contract that I've really seen.
kind of weird.
I've also seen them actually as sweeping GPs for the Guernsey partnership as well. Yeah, opportunity.
Yeah, I mean, the tax advantages now, you're not talking, they're not significant in the UK. And as I said, I think at the time, in the study we found this, until last financial year, you're probably better off taking dividends through a limited company anyway. But again, it's very marginal.
It was just that wave when it first came
Yeah.
out. I haven't
No. Yeah, so again, that's covering off just general key features of those structures, but not really something I would want to assess you on because it's just not very, it's not very challenging, is it?
That last question is just quite random.
It's challenging to know what to include, I think. I think that's the challenge. Well, that first one, I just been asked about key features. So that one on foundations, trusts and companies, the first part of it, 15 marks, the challenge is knowing what to write, what to include. Yeah, potentially, until you look then at key features and what is actually comparable between those three types of structure, and then this focus on transparency, which is necessarily going to have to take up a significant proportion of your discussion. But even then, talking about a discussion of what company records are held in the registry. I mean, it's even that's only a paragraph probably.
It's also just where do you start, because it's not actually to be found in like, it's not a legal question, but key features between like trust and companies, control, like seating control and stuff like that. That's do you get a point for that?
Yeah.
Like that's that'd be your first point to the clients, but would you get a point for that exam?
I would have thought so. Because that's what it's going to, isn't it? It's going to the beneficial owners or the beneficiaries. What, who are they? What control do they have? What protection do they have in law within this structure? That's a key feature. And hence then the same points go to the officers. That's why I mentioned them. Who are the officers? What are their obligations? How are they protected in law? And transparency. We'll take into that specifically in terms of what's held in the public domain. Beyond that, what key features are comparable between a company, a foundation, and a trust? I'm not really sure. Not directly comparable.
Would you go, yeah.
As I said, I picked up on that one because it fits as an example of what I mean when I talk about a critical discussion, something which isn't a problem question, but which is still getting you to engage in a discussion, which is not simply testing your knowledge and regurgitating the law. It's asking you to look at three structures and analyse them to an extent. But without there any meat on the bones, so you can say, do you know what suits you? Foundation. Because now, if I was going to assess you on a similar kind of scenario, there'd be enough meat on the bones that you would actually be able to make an informed view as to what would suit that client's needs. without having to know the full, the kind of full, I'm not sure what I'm trying to say, but the kind of full nuanced law that you would provide in practice, you know, as a corporate lawyer advising on a non-contentious issue. There's a lot that you would go into in terms of how you identify which of these is the most suitable structure. If I was to assess you on something similar, as I said previously, I've got to level the playing field, and so there will have to be quite clear signposts which point you, or any student, to be able to say whether they're transactional or litigators. I can see why this would be the most appropriate structure for you. Okay, if that makes some kind of sense. Question 4. I 10 to 7. I just 1.5 hours is not very long. Or it doesn't feel like it to me. Question 4 is my kind of question, or it's getting towards my kind of question, because here we've got a typical scenario, we've got some facts, we've got some issues which have occurred, and we're being asked to give a bit more of an advice to Mr. Ned. This is the kind of question, this is bordering on the kind of question that I'm more comfortable with and which I prefer. However, the first part is worth 10 marks. Provide initial advice to Mr. Ned, including his duties as a non-executive director of a PCC. Sorry, I've moved on. You guys went to 4. Oh, sorry, yeah, I did. Only because 3 is more or less entirely procedural if you read it through. Sorry, that was a point I didn't mean to make, but I just got quite excited about the fact that question 4 is a neater link into looking at the papers that I've drafted. Sorry. Question 3 is almost entirely procedural. It takes you through corporate procedure in the first section for 15 marks, with a bit of critical discussion of advantages and disadvantages. 10 is licensing, and really who cares about licensing? I know it's important in Guernsey, but it really is just reading through the relevant regulatory law and setting out what it says. I'm not sure, unless I'm missing something, not to do prisoner of service, but that is it. No, question 4 is really where I wanted to get to, because here we're being asked, advise Mr. Ned, various things happen, and helpfully, unlike my questions, I think is split up into 3 separate sections of 3 different bodies of marks being available. The first part, though, provide initial advice to Mr. Ned, including his duties as a non-executive director of a PCC. Well, that's where I roll my eyes slightly, because that's simply requiring you to give the general advice about the director's duties, what the duties are. At least that's a part of that 10 marks. I've highlighted here, including his duties. So you're providing an advice, including an advice on his duties. So that's part of your 10 marks. Have a quick read through the preceding paragraph, the actual facts, because for that 10 marks, I flagged up 3 headline areas of discussion, one of which I just mentioned. Reading through those facts, what do you identify as being the 3 or so, you may have more, you may have less, headline issues on which you would need to advise in order to get those 10 marks?
Maybe we've got cells. Cells are isolated for the fact that there are plenty of acids in lungs not forming very well.
Yeah, good. So that's my headline issue number 1. You've got to advise Ned, or Mr. Ned, on the interrelationship between a PCC's cells and the core and the cells themselves. Yeah.
Four forms on the cells, and recently there was a decision for where the bailiff said that actually, where there's been costs, where Alfred was sort of falling apart, costs would be allocated between the cells.
Okay.
So it's sort of broken down that cell structure.
Right. Just to zoom back out again, I guess you've mentioned the one
Which
about-
fits within that broad heading, yeah.
Yeah.
So I thought you were making a separate point. Sorry.
No, it's
Fits within that.
but sometimes, despite the segregation, there can be lots of across
I see.
different cells. Quite a lot of circumstances are. I tell you right now, but
That's moving into the kind of the detail of that.
Okay.
Just like Lawrence, that's zooming out in terms of the overall issues you've got to tick off here. The interrelationship of the core and the cells themselves. What else? He is also concerned that no one on the board has any experience with the assets into which Salzers invests and is reliant on the investment manager's expertise. Is there anything wrong with that, though?
I guess if they appropriately appointed investment manager have sufficient experience, I think they are entitled to rely on that.
Yeah.
Because directors are directors of the company and essentially to run the company in the right way.
Yeah.
But as concerns the investments, they've made great decisions as to the investment manager or investment advisor.
Yeah.
And as far as they can start, I don't see that being an issue.
Do you think there's any provision in the law dealing with investment managers and PCCs?
It would strike me as
Because you've asked the question, yes.
Okay, that's carved out because, and I can't remember what the section is, but professionals, whether it's solicitors, accountants, etc., there is a general carve out for them falling into that trap. But obviously it does have its limits.
Yeah, I mean, if the directors aren't getting right, and that's not just like it, that.
But we don't consider.
Yeah.
Yeah, but if they're entitled to delegate the management of assets to an investment manager. And I think the point Oliver made is
there was directors who were heavily investing in something in which they had absolutely no expertise themselves, and they just took the recommendations of them and the investment advisors or investment managers and just signed off on them without applying their minds at all, and they were all.
But that comes back to the
Wouldn't
point.
that be looking to what the investment manager is, if you put Polly Schroeder's, Jasmine, or something like that, you could expect.
The directors the investment managers.
Yeah, well, they can still consider.
Well, no, you're not at all. But what you're saying is consistent with what Oliver said. But ultimately, it comes back to the reasonableness of the appointment of the investment manager by the directors. Like you said, if the directors have appointed a big name investment manager and something goes wrong, okay, so the starting point is you look to the investment manager, yes. You then take a step back and you say, well, is there any potential liability here on the directors? You can start to get into breach of duty and what the extent of their oversight of what the investment manager is doing, and as you said, rubber stamping things. It's entirely fact specific, but if the appointment of the investment manager is seen by the court as being reasonable, I think you'd always tend to come back to, it would be the kind of formulation of the circumstances in which the court can grant relief to a director from liability for breach of duty. They acted honestly, they acted in good faith. In the kind of case law you're talking about, though, if things are more clouded than that, then yeah, absolutely, there's still scope for liability. Were you going to say?
No, I'm just going to ask how you answer this.
Yeah. Well,
Yeah, what was the third one?
I'd already said. So you're also being asked to including advice on his duties as a non-exec director. There's a very minor point there, which is that you're going to need to have regard to the fact that the law doesn't distinguish between different types of director, and so as an NED he'll be, I've just realised that's why it's called Mr. Ned, I get it. I always use like names from Star Wars and stuff, but I see, I get it now. The law doesn't obviously make any alternative provision, it doesn't recognise different types of directors, so I would imagine there's probably a mark for discussing that.
I mean, Carlisle touched on it briefly. It's not a different duty at law, but it is, I think in that case, it was said that their minimum obligation is to keep, all the words that the judge used, keep sufficiently involved and understand the business, as opposed to the MD who is also an investment force and is fully across this. Yeah, well, it falls in, the consideration of that would fall into your subjective and objective tests when you're looking through the duties themselves, I think. And you're looking to that director. Now, in fact, it probably works. It would tend, I think, in practice to work against an NED, because an NED will generally be, you might tell me it's different in Guernsey, but an NED would generally be somebody who's a career director, who's got a lifetime's worth of experience in being an FD or being an MD and has now moved into various NED roles. And so in fact, they may find themselves being held subjectively to a higher standard because of the nature of their experience. But I'm not aware of that being tested in the English law.
We certainly can.
Yeah, yeah, absolutely. Yeah.
And the 6 months thing, what we were
It doesn't have any impact insofar as liabilities are concerned, does it? There's no carve out from that point of view. Is it something that would go into, again, the application of your subjective and objective tests? Probably not. I'm not sure. I think it's just information for the sake of information, frankly. I can't believe it's gone 7 o'clock. It's just the chat was going to come and lock us in. It's 5:30 till 7, right? 5:30 till 7, and then we said 9 till 3 tomorrow. It's just a very short amount of time. Sorry, so let's just finish on this point and we'll come back to the other points tomorrow. So 10 marks, we're going to need to talk about the interrelationship between the core and the cell and the cells themselves. We're going to need to talk about the potential liability of the directors in circumstances where they've delegated to this investment manager, and we're going to need to give Mr. Ned a general advice about his duties as a director. That is a lot, I think, of information to set out for 10 marks. However, it's not particularly difficult. The first point, dealing with the interrelationship between cells and the core of the cells, touches upon, you've got sections 445 and 446 in the law, which deal with the requirement to keep assets independent as between cells and then as between the core and the cells. So I'd be expecting that you would need to discuss that. And so that's set out in 445. 446 deals with the protection then that exists in insolvency, and I suppose in general scenario. Save that, as Oliver said, there is case law then that suggests perhaps an appetite for the court to move away from that in certain circumstances. But the case that I noticed is Messenger Insurance, which deals with ring fencing, and so is actually hand in hand with the statutory protection under 446. He has been asked about this, but has been told not to worry because there are plenty of assets in the other cells. The headline point is that in the event that cell Z fails, it won't be the case that the assets of the other cells can be pulled in any significant way, certainly. And I think that the point you were raising goes only to costs, doesn't it?
I think it's
Yes, yeah. From a formality point of view, but it's not a wholesale undoing
no,
of
it's
the.
not a tenant.
No. So that is it.
It's just
It's heavily limited. So yeah, you've got probably a good paragraph or so there. There's also sections, if you were simply thumbing through the law in the exam, you'd then come across, you'd read on a bit and you'd come across 448 through 453, which deal with creditor rights and insolvency. However, this is where I always say, as a matter of exam technique, you have to sit down and read the entirety of the question before you answer any part of it, because those issues going into insolvency come out in the third part of this question. And so I don't think there's any need for you to be discussing insolvency in any real detail in the first part. I think the focus there is simply on there is no crossover between assets of cells and the core and the cells under 445 and 446. They are protected, they are ring-fenced. Now, obviously our discussion as to the use or reliance on the investment manager does get into points which we just don't have enough information on the facts to advise. There's the only provision that I flagged under the law is 445 subsection 8, which you'll all remember, because that says that the directors won't themselves be held in breach if they leave the investment of assets to an investment manager and they comply with section 445 section 2, which is the keeping assets separate and identifiable. I'm not sure section 8 takes you any further. Particularly, it simply recognises that, yeah, you can delegate to an investment manager and they are required to comply with the same provisions insofar as ring fencing is concerned. It doesn't tell us anything about reasonableness. It doesn't tell us anything about rubber stamping. It's just the one section that goes specifically to the use of investment managers in the PCC. That is it. But I think it's got to be relevant here because it goes to the use of the investment manager, but it doesn't really answer the crux, which is, well, to what extent are they entitled to simply rely on him? And you get then into a more esoteric and more kind of general discussion, as we had earlier, of, well, it's reasonable, you can do it.
for
different cells.
As long as you discharge the duties of.
Yeah.
As a director.
So again, it's one that you would risk overthinking. I think it's one that you would risk overthinking. But probably when Jasmine started telling us a story and taking us through the various thoughts, which is absolutely right, but we're not really getting to anything because we just don't know. That needs to be where you recognise yourselves in the exam. Okay, this just stop. Because I could have this kind of fairly superficial discussion, but I've dealt with the headline point, which is they can do it, and they owe these duties, and the problem is we don't know the extent to which they've got to oversee what this chap is doing, but there is scope for them to be in breach. We don't know anything. It ties in, and this is something you need to think about in terms of how you structure your answer. I've done this very black and white. 1, interrelationship PCC, core and sales. 2, reliance on investment manager. 3, general duties of the director. You might chop and change that a bit so that you could have your discussion of director's duties. Okay. I'll probably deal with the interrelationship of sales and core first because it's neat, it's done. I'll then probably look at the general duties. And you're looking at Carlisle, you're talking about what those duties are, and you're having to discuss them. You're just having to explain what they are. Duty of loyalty, best interests of the company, exercise independent judgment, avoid conflicts of interest, act for proper purposes. You could write a paragraph about each of those, and I think probably that's what you're going to have to do because you're advising on what the duties are, and there's no point in telling a lay client, well, your duty is to act for the proper purposes, or to exercise your power for proper purposes, because they'll say, well, what does that mean? What's the standard by which I'm judged? So at the very least, you've got to follow those headline duties through with, well, either in Carlisle or by reference to the English jurisprudence, this is how that duty is judged. This is the standard which is applied. So you're necessarily going to have to discuss Carlisle, of course you are, but also SPL, because it's SPL which said, in the absence of any Guernsey law, you rely on the English law as far as director's duties are concerned. So that's got to be there. There's got to be a mark for that. As I said, this is a lot of work for 10 marks. Once you've done that, though, you've set out what the duties are, just in general terms. You're just advising Mr. Ned what these duties are. It possibly makes more sense to come onto the issue of the investment manager, because you're then saying, here's section 445, section 8. Here's the point about investment managers and being subject to the same requirement to keep sale assets identifiable and separate, etc. You're then referring back to your earlier discussion about directors' duties and tying in the fact that there could be a potential breach of duty if they've just let the investment manager go off and do what he likes without any kind of level of oversight. You've got to somehow tie it in.
That's the same.
It's not specific here to a sale. There's nothing specific, I don't think, to the fact that this is a PCC. I don't think that's intended. The use of the PCC here as a structure is useful because it then goes on to the insolvency issues specific to the PCC and the sale itself. Yeah. The only other point I flagged, you've got to recognise that the NED isn't specifically identified in the law, is not specifically carved out in any way. I mean, that could be maybe not 25 marks, but the volume of what's going into that, I think it's a fairly hefty discussion, or maybe it's not in reality. Maybe just discussing that point about the cells and the interrelationship. And there's only a couple of sentences in a short paragraph in reality. And then 2/3 of a page dealing with directors' duties, maybe a bit more. just seems like a lot of work to me. Yeah. Getting into the discussion of the next two parts will take us, again, a little longer because we're looking into the insolvency law and a more practical application here. This is where it becomes more of a problem question for you. So we'll leave it there, and we can pick up on those half an hour or so tomorrow morning. And then move on to the questions which I drafted and which I can give you a bit more of a realistic insight into, well, this is what you've got to say in order to get the marks. Any other questions? Not for now.
Yeah.
No,
Thank you.
Wait until the end of tomorrow, guys. Maybe more.